But first, campaigners seeking to stop the government's high-speed rail scheme have taken their fight to the High Court today. The government have to give the go-ahead for HS2 earlier. They gave the go-ahead earlier this year because it will cut journey times from the capital to Birmingham. The route currently takes nearly an hour and a half. The high-speed rail link will reduce that journey to 49 minutes, and it should be up and running by 2026. Well, the route cuts across an area of natural beauty, so long tunnels will be used to reduce noise levels and the impact on people living nearby. Phase 2 could see the route extended to Manchester and Leeds by 2032. Well, I'm joined now by Councillor Martin Tett, who's the leader of Buckinghamshire County Council and is at the High Court for those hearings this afternoon. Just to be clear, first of all, Councillor Tett, this is about how the government reached its conclusions that I just referred to. It's a judicial review you're looking for.
Hi, Alistair. Yes, that's right. I mean, this is a judicial review. It's looking at the legality of the process. Like everybody else, governments have to follow the law, and we're arguing that very clearly the government didn't do so in this case.
But it's also, if I may say so, a bit of a scattergun approach, because you and colleagues are citing environmental questions, compensation, in your personal case, the business issue. Ministers simply say the economy's in a terrible state and needs it.
Well, let's go back to some of the fundamentals. I mean, does the economy need investment in infrastructure? Absolutely. And we've argued there are really good business cases for infrastructure investment all over this country, investing in the road and rail infrastructure that we use today, that have really good business cases that could be got off the ground quickly and could bring jobs and growth now when we need it. This project wouldn't even get built till 2026 and in the north 2033. So it's not going to bring that sort of relief that we need just when the Chancellor is talking about his autumn statement. In terms of a scattergun approach, fundamentally this morning we've been arguing on two grounds. First of all, the consultation was fundamentally flawed. This is a project where the government wants to approve it, not just from London to Birmingham, but all the way from Birmingham to Manchester and Leeds. Yet nobody north of Birmingham really knew where this route was going to go. We're going to have hundreds of thousands of people whose lives, whose homes, whose businesses are going to be blighted for decades. And it's only fair that they actually have an opportunity to participate in that consultation.
Final point to you, I mean, you have just made a very elegant business argument, but you have to win this in law on the basis that ministers got their decision-making process wrong, yes?
Yeah, I mean, there's two issues. One is we obviously disagree fundamentally with the principle of HS2 because its business case has just fallen apart. In law, we're actually arguing that the process the government has to follow legally has not been followed. They've cut corners here. They've shortchanged the public in terms of consultation, environmental impact, and the fact that there is a far better alternative that should have been followed. So we're asking the judge to find them faulty in terms of the process, and we hope that will give us the opportunity to win the argument in government that actually there is a much better alternative that's far cheaper and easier to deliver.
Martin Tett, good to talk to you this afternoon. Thanks for joining us.